Morning. If you are just joining us, we're just going to wait a moment to let others join, and then we'll make a start. Just give it a couple more moments, and then we'll make a start. Okay, we're going to make a start now. So good morning and welcome to our first webinar of 2022. I'm David Seals and I'm joined today by my colleague Heather Love, and we're going to be looking at holiday entitlement and holiday pay. And we're going to be about an hour, we think. We'll probably be talking for about 45 minutes, and then we'll have a Q&A at the end, so leave 15 minutes for that. So if you've got any questions, do type them into the Q&A box, please, at the bottom, and we'll try and get to those at the end. Now, as usual, we're going to record this webinar, except for the Q&A at the end. So we'll switch the recording off then, so don't worry. If you put any questions in, they won't be on recording. Okay, so let's make a start then. If we're talking about holiday pay and holiday entitlement, the first thing we need to look at is who is entitled to statutory holiday rights, and that's not always straightforward. So we've got these three categories here: employees, workers, and self-employed. Employees are definitely entitled to holiday rights. Self-employed people generally aren't. But we've got this category in the middle, workers. So who are workers? This is important because if we look at the legislation, working time regulations, it's workers that are entitled to holiday and holiday pay. And on the next slide, we've got a definition for workers. And that's in two parts. So workers are firstly people who are working under a contract of employment, so employees, and then people who work on another type of contract, not a contract of employment, but one whereby an individual performs work personally, and that's important, for another party, and the circumstances are such that that other party shouldn't be construed as a client or customer of a business that's being run by this individual. Now, that definition, I don't know what you make of it, whether you think that's a straightforward, easy definition or complex, but believe me, the courts and tribunals over the years have wrestled in individual cases trying to apply it to work out whether or not an individual in that particular case is a worker or not, and therefore entitled to things like national minimum wage and, for our purposes, holiday. Probably the most famous case we've had recently is the Uber case, the Uber taxi drivers, which went all the way up to the Supreme Court, with the Uber taxi drivers winning at every stage. This is a case where these taxi drivers had very sophisticated self-employed contracts, making it clear that it was their business. They weren't entitled to employment rights. And they challenged that. And as I say, they won at every stage, with the courts finding that they were workers and they were entitled to a national minimum wage and paid holiday. Probably the time you'll come across workers in practice most is if you have any temps or agency workers. So they aren't your employees, but they will be workers under the regulations and therefore entitled to holiday entitlement. That doesn't normally cause a problem, because normally the holiday pay is paid by the agency who they contract with, although it may be billed on to you as the client through the contract you have with the agency. One area where you may want to take care is over this area of consultants and whether or not they're workers. Now, you may well have people that you call consultants or contractors or something else, but they're not on your payroll. Maybe they've got their own personal service company and they invoice you. Now, if they're only with you a short time, it shouldn't really be a problem. But the longer that goes on, and especially where they become integrated into your organization, the more they may look like workers and therefore entitled to things like holiday entitlement. Now, this case on the slide is important, King and Sash windows, because if you've got a consultant like that who is designated self-employed and who's not entitled to holiday and who's with you for any length of time, beware, because that case was authority for the situation where if someone's incorrectly designated as self-employed and therefore they're discouraged from taking holiday, then they will be able to accrue holiday and indefinitely carry it forward, at least the working time directive leave. We'll come on to look at what we mean by working time directive leave in a moment, and we'll come on to look at the rules on carrying forward. Watch out if you've got any consultants. As I say, if they're not with you for long, it shouldn't be a problem. But if that situation goes on for a long time, you might want to get some advice about that. So that's an introduction into who might be entitled to holiday. Next, we need to consider what their entitlement is, and Heather's going to pick up on that. Heather, you're on mute.
Sorry. So I'll say that again. So on the next few slides, I'm going to look at some of the basics about holiday entitlement. So holiday entitlement is established by two main pieces of legislation. Domestic legislation, the Working Time Regulations 1998, sets out the rights that apply in England and Wales, but this is underpinned by holiday rights established by EU law and primarily the Working Time Directive. Additionally, holiday rights will be established by the contract of employment, and often the holiday entitlement provided under the contract of employment may exceed statutory holiday entitlement. Now, it's really important to be aware that statutory minimum holiday under the Working Time Regulations is different to statutory minimum holiday entitlement under the Working Time Directive. The Working Time Regulations provide that workers are entitled to take 5.6 weeks of leave as a minimum per year, whereas the Working Time Directive only provides for 4 weeks. Now, the reason why it's important to be aware of the difference is that cases that have come from Europe only apply to the 4 weeks worth of leave. And two cases that demonstrate this are Stringer and Pareda. Now, these are the cases that established that if a worker is on sick leave and therefore unable to take holiday, they must be allowed to take 4 weeks of leave, so the Working Time Directive leave, into subsequent holiday years. Stringer was looked at both by the House of Lords and the ECJ. The House of Lords held that the 5.6 weeks worth of leave continues to accrue whilst the worker is on sick leave, and the ECJ held that 4 weeks of that leave could be carried forward. Pareda looked at a similar but slightly different point. Pareda looked at the situation where a worker's holiday coincided with a period of sickness. And so in that situation, they also said that that worker must be afforded the opportunity to take holiday at a time when they weren't sick. And if that meant carry forward into the next holiday year, that was also permissible. So at the end of this slide, we very briefly touched on Brexit. In the run-up to Brexit, there was a huge amount of anticipation about how employment rights might be affected. And several years in, we haven't actually seen any other change. So whilst it's one to wait and watch, we wouldn't expect there to be many changes, particularly because, generally speaking, holiday entitlement under domestic law is more generous than European provisions. So moving on to the next slide. So as I said, the contract of employment is a key source of employment rights. So the contract will set out the provision, which, as I stated before, might just be the statutory minimum, the 5.6 weeks, or could be more generous. It will also state whether the leave entitlement is inclusive or exclusive of bank holidays. It's likely to also cover the leave year, which is typically the calendar year, so the 1st of January to the 31st of December. It's worth noting that if your contract of employment is silent on the leave year, that the default provisions of the working time regulations will apply. And the default provision states that the holiday year will commence on the date the employee started work and run to the anniversary of that date. Obviously, in reality, practically, if you had lots of holiday years starting on different dates, it would be really hard to track and monitor holidays. So we would recommend clarifying the leave year. The contract of employment will also state various rules for agreeing leave. So to whom the employee has to apply for permission to take leave, how much leave can be taken in one block, and how much notice has to be given of leave. It may also specify whether or not holiday can be carried forward into the next holiday year or whether or not it's prohibited. Some employers will simply state that no carryover is allowed. Others may say something like 5 days holiday can be carried forward at the absolute discretion of the employer. And if so, they may state that it has to be taken by a certain period of time. So for example, the first quarter. The final point a contract normally covers is the situation of untaken leave at termination. And it normally states how a day's pay will be calculated. Now, a day's pay needs to be calculated according to case law at 1/260th of the worker's salary, so a normal working day as opposed to a calendar day. And then this calculation would be applied either where an employer needs to make a payment in lieu of accrued but untaken holiday, or where the employer needs to recover excess leave that's been taken. Now, the contract rarely says much about the calculation of holiday pay, other than that you receive your normal rate of pay. And the reason for this is holiday pay calculations are notoriously difficult. They're fact specific. The normal rate of pay can be quite a complex issue, as we'll come on to, and it would be absolutely impossible to cover this point within one clause. So in addition to the contract, the working time regulations are the key piece of domestic legislation that establishes holiday rights. So as stated before, workers are entitled to 5.6 weeks of leave. This is made up of 4 weeks of leave from the European legislation, the Working Time Directive, plus an additional 1.6 weeks of leave. Now, we covered in the contract that employers can set out notice entitlements for leave, but these are also covered by the working time regulations. The working time regulations allow the contract to vary these provisions, but I'm just going to run over what the default provisions are in the case that the contract's silent. So what the working time regulations say is that if an employee wants to request leave, they have to give employer notice in the sum of twice the duration of leave that they want to take. So this means if an employee wants to request 5 days of leave, they would need to give 10 days notice. Likewise, this rule applies to an employer who wants to ask the employee to take holiday at a particular date. So for example, if an employer wanted an employee to take 3 days of leave, they would need to give 6 days notice. The working time regulations also provide a rule for an employer to give counter notice to prevent the employee from taking leave on a certain date. Now, this rule is fairly, I guess, difficult to explain or confusing, so I'm just going to read it. And what that rule states is that an employer may refuse a worker's holiday request by serving counter notice. This must be given at least as many calendar days before the date on which the leave is due to start as the number of days which the employer is refusing. So for example, if an employer wants to refuse 5 days of holiday, they need to tell that employee 5 days before. Now, this sounds great in theory, but if an employee has booked a holiday to Spain, for example, and 5 days before you tell that employee they're unable to go, that employee is likely to be pretty disgruntled. Added to which, there may be a breach of the fundamental duty of trust and confidence and could potentially give rise to claims. So the working time regulations are very much a health and safety provision, and they state that working time directive leave, so the 4 weeks, must be taken in the leave year in which it's accrued. Additional leave, so the leave over and above the 1.6 weeks, can be carried forward into the next holiday year. Now, this is the general rule in normal circumstances. However, the working time coronavirus amendment regulations, which were introduced in 2020, now allows for the carry forward of the 4 weeks of the working time directive leave into the 2 subsequent holiday years. Now, this is in situations where it hasn't been reasonably practical for workers to take it. So a classic example of this would be NHS staff, frontline staff, who were required to work pretty much all the time during the pandemic. There are 2 other exceptions where leave can be carried forward into the next holiday year. Sickness absence, as we discussed. So again, the working time directive leave can be carried forward into the next holiday year. The working time regulations do say that an employer can require that leave to be used up within the subsequent 18 months. The other exception for carry forward is leave accrued during a period of statutory family-friendly leave. So family-friendly legislation provides that contractual benefits continue to accrue during such leave. You can't be on 2 types of leave at the same time, and therefore you must allow employees to carry it forward into the next year. So the final point on this slide is a payment in lieu of holiday. This is only allowed on the termination of employment. And the reason for this is the fact that this legislation is designed to protect the health and safety of workers. The idea is if employers were allowed to make a payment in lieu, it would discourage workers from taking holiday as they would rather bank additional payment. The final point on this slide is rolled up holiday pay. This is something I'm going to come to look at later in the presentation, but rolled up holiday pay is also prohibited for the same reason. It is effectively a payment in lieu of notice and therefore is seen as a measure that would disincentivize staff from taking sufficient breaks throughout an annual leave year. So we talked about the 5.6 weeks of leave, but what actually does this look like? So for a full-time worker who works Monday to Friday and the same hours each day, this is really straightforward. It's just 5.6 times 5, so 28 days holiday. For a part-time worker, it would be 5.6 weeks of their normal working pattern, whatever they may be. Bank holidays are not specifically mentioned in the working time regulations. They can count towards statutory entitlement if a worker would normally work those days, but they don't have to. And it's certainly a myth that employees that don't normally work on bank holidays aren't entitled to a pro rata equivalent of those amounts, whether or not they're included in the overall calculation or added on in addition. And this is because part-time workers are prevented by the Part-Time Workers Prevention of Less Favourable Treatment regulations from being treated any differently to full-time workers. So the key message is it's very important that part-time workers receive the pro rata amount of the equivalent full-time workers' holiday allowance. I'm going to hand back to David now, and he is going to talk through a calculation for a part-time worker.
Thanks, Heather. So what we got on the slide here is an example of a part-time worker. This isn't from a case or even from any government guidance, but we've just put this together. We're pretty confident it's right. But just to work through it with you. So we've got this company, ABC Limited, and they have full-time staff and they have some part-time staff, and the full-time staff work those hours 9 to 5:30 with a 1 hour lunch, Mondays to Fridays. So that is a 37.5 hour week, which is pretty standard, we find. And those full-timers are entitled to 25 days holiday plus the bank holidays. So enter a part-time worker, Sharon, in the marketing department, and she works the same hours, 9 to 5:30 with the same hour lunch, but she only works Monday to Wednesday. She doesn't work Thursdays and Fridays. So what is she entitled to, bearing in mind the working time regulations and the need not to discriminate under the part-time worker regs that Heather just mentioned? Well, Sharon's hours are 22.5. If you take 3 days, 7.5 hours a day each. If you divide that by the full-time hours, 37.5, you get 0.6. So she's entitled to pro rata 0.6 of the same holiday that the full-timers get. So we make that 187.5, which is the full-timers 25 days holiday expressed as hours, times 0.6, 112.5. So leaving the bank holidays for the moment, the pro rata entitlement for Sharon is 112 hours. And as I say, she's also entitled to bank holidays. So what do we do there? Well, we've taken the bank holidays, which are 8, and we've times them by 7.5, because that's how many hours a full-timer would work on those bank holidays. If they work those days, that gives you 60 hours. Then we times that by 0.6 as well. So that gives you 36 hours pro rata for the bank holidays for Sharon. So her total entitlement to holiday, including the bank holidays, is 148.5. And then whenever she took holiday, or wherever a bank holiday fell on one of her normal working days and she didn't have to work because of that bank holiday, you would deduct 7.5 from her holiday entitlement. Now then, that's part-time workers. What about shift workers? You may have those. And shift workers could give rise to a bit of confusion perhaps over what their entitlement is, because of course the working time regs, as we've seen, only talks about workers being entitled to 5.6 weeks leave per year. And it can be difficult with shift workers where they don't work in weekly patterns. So what we've got here is an example. This is actually taken off the gov.uk website. And again, this isn't law, but this is government guidance on how you might deal with a shift worker. So hopefully this should be reliable. So here's an example. We've got Wanda, and she works shifts where they don't vary in length. That's important. The shifts are all the same length. And she works 4 shifts every 9 days. So 4 days on, 5 days off. So what the government guidance says is that it might be more helpful to express that holiday entitlement for a shift worker in terms of shifts per year that they're entitled to take as holiday. So taking Wanda's example, you do 4 shifts, divide 9 and times that by 7, and you get 3.1. So that is the average number of shifts she does per calendar week. And then her statutory holiday entitlement, remember she's got to be given 5.6 weeks leave, would be the lesser of 5.6 times 3.1, which is 17.5 shifts, or 28 days. That's because, as you remember from the previous slide, the maximum days you can have as leave under the working time regs is fixed at 28. Okay, so it's the lesser of those two. And so in Wanda's case, it's 17.5 shifts. So that's her holiday entitlement for the year. Now, as I say, that only works, that method of calculating the holiday entitlement for shift workers, if their shifts are all the same duration. What if they vary? Well, if they vary, you have a problem, because depending on whether they're taking holiday on a shift, which is a shorter or a longer shift, then it's going to mess up the entitlement. So in those kind of cases, and what the government guidance says is you should use an hours calculation, a bit like we've done with the part-time workers, and that will obtain more accurate results. Now, casual workers, 0 hours workers. Now, this is a really tricky area because working time regs, as we've seen, says you're entitled to 5.6 weeks leave a year, and that's absolutely straightforward if you know what the working pattern is going to be. If someone works full time all week, you know that what 5.6 weeks is going to look like. But with a casual or 0 hours worker, by their nature, you don't know what they're going to be doing. I mean, you may give them an assignment where you know they're going to be working a block of so many weeks, so many days, whatever. But generally speaking, with casual 0 hours workers, it's uncertain, and that's why they're on that contract properly, because you don't know what work you're going to have for them, so you want to keep it on that basis of a contract that doesn't guarantee them work. So how do we deal with their holiday entitlement? Well, it's really difficult. There's no case law on this. There's nowhere we can look in the case reports that will tell us how to do this. Now, there is one possible way of doing it, and that is to treat a week as an average number of days, hours worked over the appropriate reference period. And I'm just going to go through this method with you now, but I can guarantee that you're almost certainly not going to use it for reasons I'll come on to in a moment. But anyway, let's go through it. So this is the theory. So we've got Terry, who works in a warehouse, and he's on a 0 hours contract. And he's worked in his warehouse for 10 weeks. And during that time, he's worked 39 days. And he now wants to take a day's holiday. So what you could do in that situation is say, well, let's work out what an average week is, because we know he's supposed to accrue 5.6 weeks a year under the working time reg. So an average week in this case would be 39 divide 10 equals 3.9 days. Yeah, because that's the average number of days he's been working. So if that's right, a day's leave would be 1 over 3.9 or 0.26 of a week. So if he took a day's holiday, the employer could treat that day's holiday as 0.26 of a week and pay Terry 0.26 of a week's pay. We will come on in a minute to how you calculate a week's pay. That's a whole other area of potential complexity, which we'll look at in a second. But the point is, for the holiday entitlement, we worked out that he's taking 0.26 of a week, so we would knock that off his entitlement, and he's got, in this case, 5.34 weeks remaining. Now, if you're going to use this method, weeks with no pay should be ignored, and days of paid holiday should be included in the calculation. Now, as I said at the start of this slide, you're probably not going to use this method. The reason being is it's really quite complex, and you have to do a separate calculation probably each time, and that rate of pay and the fraction of the week is going to fluctuate depending on what the working pattern's been. So it's complicated. Now, I don't see why someone can't invent some software to deal with this. It would probably be a lot easier then. I've looked at this in the past to see if there's any software available. I'm not aware of it. So if you do know, please let us know, because we've got clients that would probably be interested in hearing about that. Now, as I said, that's probably not a method that you're going to be tempted to use because of its complexity. But let's look on the next slide at what normally happens. And that's this method, the accrual method. And the way this works, let me go through that. We've got this percentage of 12.07%. You might have seen that before. And the way we get that is we say 52 weeks in a year, and then we take off the 5.6 weeks holiday entitlement under the working time regulations. That gives us 46.4 working weeks each year. And then if you do the maths, 5.6 comes out at 12.07% of 46.4. So if we then apply that to Terry's case, he worked 39 days in that period. So using the accrual method, we'd say 12.07% of 39 days equals 4.7 days. So after working 39 days over 10 weeks, he's accrued 4.7 days holiday that he can take. So that's used a lot. That's a common method. I've seen that in practice, that employers are using that. And generally, they don't have any problems with it. But it could be problematic where there are periods of no work, which is quite possible in a 0 hours situation. And that was flagged in this case of HARPER Trust and V-BRAZEL, which we're going to have a look at now. Now, this is a difficult case, and we're not going to go into detail on it, but the basic facts are these. In this case, the claimant was a music teacher, and she worked varying hours and normally term time only. And she was paid for the hours that she did. Okay. And she was required to take holiday outside of term time, as is normal with schools. But what happened was she was paid a lump sum at the end of each term, based on 12.07% of the hours that she worked. And that was actually the agreed arrangement that they had. But she later challenged that in tribunal, and as we'll see, it eventually went up to the Court of Appeal. And she was saying, look, what you've done here actually breaches the rules, because under the working time regs, we have to do a calculation, and for that we then go to the Employment Rights Act. We'll look at that in a moment. And what you should have done is paid me holiday pay based on my average pay over the last 12 weeks. Okay, now remember, she's on this contract, which means it's a permanent contract, but she's working generally term time only. So there were, in her case, there's over 20 weeks in the year that she wasn't doing any work. And in fact, she could have done whatever she liked during that period. But she was saying under the rules, the calculation should have been over the 12 weeks. Incidentally, this reference period changed recently. It's now 52 weeks. But at the time of the case, over the last 12 weeks, when she would have been working in term. Now, applying that method, it was found that she would actually end up 17.5% of her annual earnings if you worked out the holiday pay on that basis. And of course, the employer thought that was completely unfair, and she was getting disproportionately more holiday pay than, for example, colleagues. Anyway, she won all the way through to the Court of Appeal. So if we just go on to the next slide, the BRAZEL case throws up some challenges there. If you've got anybody on a permanent contract who has got periods where they're not working, because the effect of BRAZEL is, what it's saying is that you're continuing to accrue holiday during that time, even though in theory, probably these people can go off and work for other people even. So be careful in that situation. And what you want to try and avoid is having an arrangement where you've got what we call an umbrella contract. So for instance, you may have 0-hour staff who come in and work for a period of months, and then they maybe have a period of downtime where they're not working for you, then you bring them back. Well, that's okay. But if there's a contract in place the whole time, then they're probably accruing holiday entitlement. So what you should do is make sure that doesn't happen. So the contract is quite clear that during assignments, fine, they get paid and they're working and they'll accrue holiday entitlement. But between assignments, there's no contract between the parties, and they're not accruing holiday. So if you don't get anything else from this webinar, there's a useful tip. Look at your casual staff, your 0 hours people. What contractual arrangements do you have in place for them? Because they could be entitled to holiday pay quite unexpectedly that you weren't bargaining on. Now we're going to look at holiday pay, rolled up rates of holiday pay, and I'm going to hand over to Heather.
So I briefly mentioned rolled up holiday pay before, but I didn't actually explain what it is. So rolled up holiday pay is where normal pay includes an enhancement on account of holiday pay, but it's actually paid at the time that the worker is doing the work and not at the time that they're on leave. And so the 12.07% rate, as David has just outlined, is often used to calculate what this enhancement would be. Now, the case of Robinson and Steele is really interesting because in that case, the ECJ held that member states should be doing everything possible to outlaw the practice of holiday pay, And as stated previously, it's prohibited by the working time regulations. However, what that case said is that where a worker has received rolled up holiday pay, they should be given credit for any holiday pay received, provided it's transparent, comprehensible, and a fair amount on account of holiday pay. So this case was a claim by a worker who'd received holiday pay, but he was saying, you know, he was wronged because he hadn't actually received a payment at the time he was on leave. And so what this case has done is it's left employees with a right to complain that holiday pay is unlawful, but effectively without a remedy where the rolled up holiday pay is transparent, because credit will be given for all sums received. So what do we mean by transparent? Our interpretation is that for something to be transparent, there must be clear written contractual terms. So it would state the normal rate for work done and an additional amount on account of holiday. And when you issue your employees or workers with a pay slip, that would need to show a payment for work and an additional separate amount for holiday pay. So moving on to the next slide. So over the course of the next few slides, between David and I, we're going to talk about how you calculate holiday pay under both domestic legislation and European legislation. This can create difficulties because they clash. So I'm going to begin by looking at domestic legislation. So the working time regulations states that a week's pay should be calculated in accordance with the formula in the Employment Rights Act 1996. Now, there are different formulas depending on whether the worker has normal working hours or whether they're a variable hours employee. Where the worker has normal working hours, holiday pay is generally based on their normal basic pay. So this would exclude commission, bonuses, and voluntary overtime. The exception would be compulsory guaranteed overtime. Now, as David will come on to explain, this clashes with European case law. For workers that don't have regular hours or where pay varies according to how much work is done or the rate of pay, holiday pay is averaged over a reference period. Now, this reference period was previously 12 weeks. It's now been extended to 52 weeks, or the maximum time that you can get if an employee has been employed for less than 52 weeks. Two important points to note are it's only weeks in which pay is received that can be included in the 52-week calculation. And where you're trying to get a total of 52 weeks, the maximum time you have to go back for is 104 weeks. So I'm now going to hand back to David, who's going to take you through some of the European cases and highlight where the European approach is slightly different.
Thanks, Heather. So the problem with the rules that are set out in the Working Time Regs and the Employment Rights Act is that very often workers only get paid the basic pay when they take holiday. And this led to some cases where people were challenging that and saying, well, look, if I take holiday and I only get my basic pay, I'm actually going to be worse off than I normally would be because my normal pay might include various other things like overtime, pay supplements, commission, and so on. And this went all the way to the European Court of Justice in this case of Williams and British Airways, 2012. Now, this is a case about airline pilots, and it's class action. So a lot of claimants bring a claim here with the help of their union. And in that case, as I understand it, British Airways pilots get these flight pay supplements on top of basic salary, which are significant. And British Airways weren't paying those supplements when they took holiday, which is paid basic salary. So the pilots challenged that, and European Court of Justice looked at it, and they found in favour of the pilots. The idea is as Heather said, that holiday entitlement under the European directive is very much a health and safety measure. It's all about workers getting an opportunity to have adequate rest. And in the view of the European Court, if workers are discouraged from taking holiday because they're going to get paid less, then that's counter to the policy objectives of the legislation. It's the same with the rolled up rate of holiday pay. If you have a rolled up rate of holiday pay in the normal pay, and then you don't pay any holiday pay when they actually take the holiday, workers are discouraged from taking the leave. So that's why holiday pay that's rolled up is said to be unlawful. So it's the same principle here. Workers should get their normal pay, and that in the British Airways case, that included these flight pay supplements. And then after that case, we've seen a succession of further judgments where incrementally the law's been changed and developed along this principle. So in Locke and British Gas, the issue there, again, that European Court of Justice, that was a case that involved workers that got results-based commission, where they didn't get the commission if they took holiday. And so the claimant wasn't happy about that, brought that claim, and the European Court of Justice found in his favour and said, yes, results-based commission should also be included in the calculation. Now, as we come on to what's a bit confusing about this situation is the European Court of Justice, they're making decisions about the EU directive. So that only affects the 4 weeks leave that you're entitled to under the working time directive. It doesn't include the additional 1.6 weeks leave under the working time regs, or indeed any extra contractual entitlements you've got. So that makes it confusing. Anyway, the case is continued, and then in Bear Scotland, they were looking at non-guaranteed overtime, whether that should be included in the calculation. Non-guaranteed overtime, what we mean by that is overtime where there's no obligation on the employer to offer it, but that if they do offer it, the employee has to work it. Okay, so in that case, the decision was that that kind of overtime should be included in the calculation. And then finally, in Dudley, Council and Willits, they looked at a case that involved various pay supplements, and that included voluntary overtime, which is the normal one, which is where the obligation to offer it, or rather there is no obligation to offer it, and the employee can voluntarily do it or not. It's up to them. So that's the normal overtime situation. So that kind of overtime plus standby payments and call out payments, they were all paid regularly in that case, and the decision was that those kind of regular payments should be included in the calculation. So various decisions there from those cases that have subtly changed the law on holiday pay over the years. So where does that leave us? Well, it leaves us in a slightly confused state, because if you, as I just mentioned, those decisions only apply to the working time directive leave. So how would you deal with that in practice? Would you apply a different calculation to the four weeks of the leave, and then another calculation to the extra 1.6, and indeed the contractual that might be on top of that? Or do you just pay it all the holiday entitlement at the enhanced rate that includes all these things? So that's obviously going to be increased costs for you. And if you are going to differentiate between the working time directive leave and the other entitlement, how would you actually apply that? Would you say take the 4 weeks that they take first in the year and apply the calculation to that, and then a different calculation when they take the last bit of leave? There's no law on this. Then another problem is, how do you actually apply the calculation? Say you are going to take these things into account. You've got workers that do overtime, have pay supplements. You're going to put it into the calculation. You want to comply with this case law. How do you actually do it? Well, there's no guidance on exactly how you do it if it's a case with normal working hours. If it's as we saw on the slide that Heather looked at, if it's a non-normal working hours case, then you've got that reference period, the 52-week reference period. If it's a normal working hours case, there is no guidance on what reference period you use. So what would you do? Would you look at the last month, last 3 months? Would you go back a year? You know, there isn't a case law decision on this. So whatever you do, it could be challenged. And it could be challenged if people are working, their working pattern is such that they get different pay throughout the year, and a particular reference period might be more beneficial than another one. Another grey area is, what does sufficiently regular mean? We saw in Dudley Council and Willits, this only applied, this rule of taking these things into account, if they were sufficiently regular. What does that mean? Does that mean that people need to do overtime on a weekly basis, a monthly basis? What if they only work overtime once in a blue moon? It's really unclear. And bonuses is the grey area. So in Locke, results-based commission was said to be a type of payment that should be taken into account in the holiday calculation. But what about bonuses? You know, people often have a annual discretionary bonus. It's really unclear as to whether those are something that should be taken into account. Probably at the moment, our advice is on balance there shouldn't be, but this is an area that could develop further. And as we said at the beginning, there's no planned law reform on this that we're aware of, even though with Brexit, we could now, Parliament could change the law and put a different regime in place. But at the moment, we are still effectively stuck with this sort of jigsaw of case law that points the way, but leaves some grey areas for us. Okay, well, that is 46 minutes. I said I'd be 45, so that's pretty good. We're going to now look at some questions. So, Heather, we've got one for you.